2 days of the 7, I'm counting 2 of the 10.
I'm going to outwit Judge Mogen, and you thought you're smarter than everyone else in the room. I was number 2, law school graduating class. What fool's going to pay like almost $3,500 a night? It's absurd, and I can't believe you think that a court would fall for it. 90 days in custody, immediate.
When you choose to live in a nice, secluded place on the lake, the last things you want to deal with are loud parties and commotion every weekend at the AirBnB next door. That's why some places cap the number of nights you can rent your place out. Mr. Auleciems believed he could skate through the ordinance by calling some of the nights in his Vrbo free. He also thought he could disobey Judge Mogen's order from last year, permanently enjoining him from renting out his place at all. Now he's earned a 90-day, all-expenses-paid vacation at the Burnett County Jail. You can't show your ass to a judge and expect anything different, can you? Let's roll, nerds.
An order from the court of October of 2024 that requires Mr. Auleciems to not rent his property unless he has the proper permission and licensure from the state and the county. He is, by his own admission, he does not have that and has never applied for it as far as I know. Last summer, in the affidavit of Rick Brimacombe, it's also outlined that there was 5 different periods of rental. And we can go through the specifics of that in testimony, but there was 1 in May, 1 in June, 1 in July, and 2 in August, all in violation of the court's order. And so therefore, Your Honor, the court's order was violated again, and it was already violated previously by Mr. Auleciems. And so we are asking for a finding of contempt and appropriate sanctions relating to that contempt.
All right, thank you. All right, Mr. Auleciems.
In response, the order doesn't say I need a license. The order says permission of the county. And the ordinance says it's 10 days or less. And it's my intention to rent the property for 10 days.
All right.
And that's what I'm claiming I did.
All right. The order says what the order says, and I'll have to interpret my own language in my order when we get to that. But Mr. Anderson, please call your first witness.
Call Carl Auleciems.
Mr. Auleciems, please come forward. You're going to raise your right hand. You're going to be sworn in and come have a seat at the witness stand.
Mr. Auleciems, you rented property in Burnett County over the summer of 2025. Is that true?
Yes.
Okay, and you rented that property May 24th through May 26th. Is that accurate?
I don't recall the exact dates.
Okay, do you recall renting the property in June?
I don't know specifically.
Okay. Do you recall renting the property in July?
Yes, I do.
Okay. And that was to a James Bennett, true?
Yes.
Okay. And you rented that property from July 19th through July 26th?
I don't recall the exact dates, but I have the rental agreement there as an exhibit.
Okay. They were at the property from July 19th through July 26th, as far as you recall?
I don't recall the exact dates, no.
Okay. Were they there for approximately a week?
I believe so, but again, I don't recall the exact dates.
You charged Debbie Tate to rent the property over Memorial Day weekend, true?
Again, I don't remember exactly who it was.
Okay, but you charged whoever rented the property over Memorial Day weekend, you charged them to rent it from you, true?
Yes.
Okay.
What I did is I said that 2 days of the 7 were paid and the other 5 were complimentary to kind of save 5 of the 10 days. So of this, for Mr. Bennett, I'm counting 2 of the 10 for that purpose.
Okay. Got it.
And that's what's shown here on the rental agreement.
How long were you and your group at the property in July of 2025?
We were there from July 19th until July 26th.
Okay, so you're there 7 nights?
Correct.
And how many were in your group that stayed at the property?
There were 14 of us.
Okay. Do you recall how many vehicles were up there?
There were 5, I believe.
Yeah. Any recreational vehicles of any sort?
We did bring our boat, which was parked on the water.
What was the purpose of your trip to northern Wisconsin that day or that week?
It was our yearly family vacation.
Okay. How was your stay up in northern Wisconsin?
It was very nice. The weather cooperated, and we had a great time.
Mr. Bennett, in looking at Exhibit 3, it says $6,950.48. Is that what you paid?
Yes, it is.
Okay, and that was to stay at the property for 8 days and 7 nights. Is that accurate?
Yes.
And then looking at Exhibit 4, it says booking confirmation and then rental agreement. Do you know how you received this document?
Yes, we received a link to it in the Vrbo messaging app, the Vrbo messaging app.
Okay, and do you remember when you received this document?
Yes, we received it the night before our vacation started, about 5 or 6 p.m.
Okay, and so that would have been July 18 of 2025?
Correct. My wife brought it to my attention that he had showed that part of the stay was complimentary and that we actually only paid for 2 days and that the rest was complimentary. She brought that to my attention, and then I looked it over again.
Okay. Did that give you any concern?
Yes, actually a great deal. We were concerned that he may have been trying to leave himself an out to force us to leave early. Our thought was that maybe he had double booked it and was giving himself a reason to evict us early.
Okay. Ultimately, you were able to stay for the entire 7 nights, 8 days. Is that true?
Yes.
Yeah. Would you have paid nearly $7,000 for a 2-night rental?
No.
Okay. Your understanding was that you paid for 7 nights, $7,000 almost for 7 nights and 8 days. Is that correct?
That is correct.
How long were you and your group on the property in northern Wisconsin?
2 days.
Okay. May 24 through May 26?
Well, I guess technically 3 days if we're going to do that.
Yeah. And I don't really care about that too much, but 2 nights, you stayed there 2 nights?
2 nights, correct.
Okay. How many were in your group at the property?
There was 12 total, 1 night, and 1 night there was 10.
Okay. What was the purpose of your trip up north?
We brought side-by-sides up, and we went on local trails in Wisconsin. My mom is very sick with dementia, so we just had a family. It was me and my siblings and my parents. So it was just a quick family getaway.
Good. And how was your stay up there?
It was very nice.
Good. You had a good family time?
Great family time. Thank you.
Okay, Ms. Tate, you testified that you paid $2,864.33. Is that correct?
Yes, that's correct. Sorry.
And how much of that were fees going to VRBO?
Objection relevant.
Sustained.
And of the 2864.33, what was the amount that went as a service fee?
Same objection.
Sustained.
And how much went as a tax?
Same objection.
Sustained.
No further questions.
All right, thank you. I'm just going to direct all parties that the issue here is contempt and renting the property. It has nothing to do with the value you received, the total amount of dollars. Mr. Auleciems, you may begin.
Well, very briefly, Your Honor, the order that you wrote does not say that requires a license from the county.
Let me read what my order says. Okay. Words are words, and I used words. Order said, the court finds that the plaintiffs have met the burden of proof and that there is no genuine issue as to a material fact. The facts asserted by plaintiffs are not refuted by fact or evidence and are so clear and convincing to the trier of fact that there is nothing left to establish. As such, the court hereby issues a permanent injunction, that's in all caps and bold, until such time Mr. and Mrs. Auleciems comply with and receive the state DATCP rental license and the Burnett County rental permit, and continues to do so annually as required, and until such a time that the above depicted nuisances can be abated. That's what the court said.
Well, my understanding of the order in conjunction with the county ordinance says that 10 days that I can rent the property for 10 days or less without any kind of county permission, license, anything. That's what the county ordinance says, and I believe that's what the right to rent state law makes a reference to that as well. So under that understanding, again, your order has to be in conjunction with the ordinance.
No, it doesn't.
Well, if the ordinance says something, you can't change the law.
That can be your argument. I will tell you what I can do as a judge when I'm going to make my decision. I will stop.
Right. Well, the ordinance says that I can rent for 10 days and not have to get any licenses, permission. Nothing.
Your Honor,
So
you've made the comment already about argument. I was going to do that earlier, and there hasn't been any actual testimony so far. This needs to be factual. The argument can be made from there or in
I'm just
writing.
laying a foundation for my state of mind.
All right. Well, I don't need a foundation for your state of mind. I understand you've heard my order, the words that were in the order, and I heard that you believe that the ordinance states you can rent for 10 nights or less without needing to get the permit. Okay.
Right. So I went ahead and rented my property for 10 days for this past summer, 2025.
All right. So I'm hearing right now, I just have to make sure you are admitting and stating on the record you rented it for 10 days.
Correct.
All right.
Mr. Auleciems, to be clear then, you did not receive permission from Burnett County to rent your property in Burnett County, true?
I never asked them for permission.
Fair enough. Then you never received a license from the state to rent your property in Burnett County, true?
No, because my understanding is I didn't need a license for 10 days or less.
Okay, so no, you didn't.
No.
No further questions. Your Honor, I think sanctions are appropriate here. He's already been found in contempt of court for this very same action in the past. The court sanctioned him then. I think the court should sanction similarly. I think Mr. Auleciems is right. He predicted that well because I think I did it last time. One that shows that the group that was there in August 28th through September 1st was there for 4 nights. It says $995 times 4 nights. We have testimony from Mr. Bennett that they were there for 7 nights and 8 days. And they booked their vacation, I think he said 7 or 8 months prior to the vacation actually occurring. And then we have a rental agreement sent to Mr. Bennett at 5 p.m. the day before they are supposed to go to the property that owned by Mr. Auleciems for their 8-day family vacation. And obviously they signed it and moved on. And then they looked at it later and saw that there was this clause in there about complimentary days. That is a sneaky way of trying to get under the 10 days, which I don't think applies anyway in this case. But even if it does, Your Honor, the point of it is they were at the property for 7 nights and 8 days. The people from August 28th to September 1st were there for 5 days and 4 nights. We're already at 11 nights between those two. And then we have Debbie Tate, who was there for 2 nights and 3 days. Now we're at 13 nights and more days. And then not even to mention the other two groups that were renting, one from August 8th through August 15th, which again is another 8 days and 7 nights. And the last group being June 6th through the 8th. That was the one with the ambulance. There's less information about that, frankly, but there was extenuating circumstances there. But point being, Your Honor, there were renters there in far greater numbers than 10 nights. And again, I don't think that applies, but since Mr. Auleciems is arguing it, I feel like I should respond to that because we are at 13 nights just for the 3 groups that have been proven here today in court without even considering the additional 2 groups. So any way you slice it, Your Honor, whether it's by what I consider the letter of the law in terms of he's not supposed to rent, period, without a license or permission from Burnett County. But even if we do have if that is the law, which I don't believe it is, he's still in violation of it. So frankly, a lot of the argument from Mr. Auleciems doesn't matter because he's in violation either way. But I think that the profits and the money that was received by Mr. Auleciems are ill-gotten gains in a case like this, and those should be forfeited by him as a sanction. And then I defer to the court on additional sanctions. There was, in the prior contempt order, Your Honor, there were purge conditions. Obviously, those purge conditions did not happen. And now we're here on round 2.
Purge conditions were ordered by the court to Mr. Auleciems, and pursuant to the court's order, Mr. Auleciems did not comply with the purge conditions.
My understanding was 10 days. That was my intention. Mr. Anderson's math quite adds up, but they've only presented Mr. Bennett and Ms. Tate. That's 2 days and 2 days. That's 4. Again, it was my intention to stay under the 10-day limit. I think even you made a reference yourself at the beginning of the hearing that it has to be within the ordinance. The ordinance is 10 days.
I said that was your argument.
Right, but that's what my understanding was, that that's any person in the county would get 10 days. I don't see why I would be any different.
I said nothing about any ability to rent at all. It's a permanent injunction, permanent until you do those 2 things, all right? Until you do those 2 things. You did not do any of those things. Instead, you rented it, you were found in contempt, you had far more days for the rental at the last contempt hearing. So the court found you in contempt, and this case, you're like, I'm gonna outwit the legislature, I'm gonna outwit the Burnett County Board, I'm gonna outwit Judge Mogen and Attorney Anderson. That's what you thought. You thought you're smarter than everyone else in the room. You are not smarter than anyone else in the room. I was number 2 out of 105 people in my law school graduating class, okay? You violated the ordinance. Free days count, Mr. Auleciems. Free days are not free days, especially when you're charging $6,980.48 for 2 days. What fool's gonna pay like almost $3,500 a night? A fool would pay $3,500 a night. It's absurd. It's ridiculous. And I can't believe you think that a court would fall for it. The Court of Appeals will not fall for it. I'm telling you that. They're very smart. Probably smarter than I am. They do this all the time. They're not gonna fall for your shenanigans. They're not going to. Specific parameters in place that you must follow, because it's been shown that you do not follow. You don't follow the law. You don't follow what the legislature says. You don't follow what the law enforcement says. You don't follow what the court says. You don't follow what anyone says but you. So I'm denying your motion to stay. And I'm finding you in contempt of the court's contempt order. I'm imposing those sanctions. You failed to pay $5,000 by October 27th, 2025. That means that the jail sentence stays 90 days in custody immediately. As to the other parts of the order, the court will again stay on that and we'll get it out. So you'll be remanded to custody for your 90-day sentence. You failed to purge. You did what you want.
Your Honor, can I purge right now?
No, you didn't have the money. You literally just said on the stand. Stop.
I have a credit card.
Stop. You literally said on the stand or on your table under oath, but I don't have the money. I can go back on a transcript. I can go back. You said those words.
I don't have it. I have it on a credit card, though.
That's money. You could have paid it on a credit card by October 27th, 2025. But if you read my order clearly, words are clear, by October 27th, 2025, then the jail goes away. It's February 6, 2026. Far beyond that. The court's enforcing it. You're remanded to custody immediately, 90 days. Thank you. We're adjourned. Sometime you have to start abiding by the law and orders of the court, Mr. Auleciems.
Can I purge, Your Honor? I have a lot of business and things that I wasn't.
Well, what you can do is you can pay it and then you can write a letter to the court and then I'll consider it. But right now my order is very clear, very clear. The purge condition was very clear. So if you would like to pay it and then you would like the court to, it's called reconsideration, you sure can do a motion to do that.
Can I do that right now?
No, you have to go up to jail.
How would I make?
Go up to jail.
Okay.